Hello and welcome to Courts This Week at LiveLaw. I am Taniya Pandey, back with the latest judgments for you. First, let's go over the developments in the case of farmers' protests. Supreme Court's actions in the Farmers' Laws case have provoked a barrage of criticism. However, notice was issued in an application filed by the Bharatiya Kisan Mahapanchayat seeking the reconstitution of the committee constituted by the Supreme Court on January 12th on the ground that the members have expressed views supporting the implementation of the farm laws. The Chief Justice of India, however, remarked that unnecessary aspersions had been cast on the committee members and they were maligned just because they had expressed certain views in the past on the farm laws. We will not pass orders, you withdraw it. Supreme Court on an application filed by the Delhi police seeking an injunction against the tractor rally proposed to be carried out by farmers in Delhi on Republic Day. The Apex Court remarked that Delhi police is the deciding authority and the norm is that police decides if permission should be granted or not. The Supreme Court, by 4:1 majority, has dismissed a batch of review petitions challenging the judgment of the Constitution Bench in the Aadhaar case. Justices A.M. Khanwilkar, Ashok Bhushan, S. Abdul Nazir and B.R. Gavai observed that no case for review of judgment dated 26 September 2018 was made out. Justice D.Y. Chandrachud dissented. The review petitions assail the reasoning in the opinion of the majority on whether the Aadhaar Act was a money bill under Article 110. The majority observed that change in the law or subsequent decision or judgment of a coordinate bench or larger bench by itself cannot be regarded as a ground for review. Justice Chandrachud, however, remarked that the question as to whether Aadhaar Act was a money bill under Article 110 has been doubted by a coordinate bench in Roger Matthew and that it would be a constitutional error to hold at this stage that no ground exists to review the judgment. Justice Chandrachud opined that if the review petitions were to be dismissed and the larger bench reference in Roger Matthew were to disagree with the analysis of the majority opinion in Aadhaar judgment, it would have serious consequences, not just for judicial discipline, but also for the ends of justice. The prescription of a higher educational qualification as a qualification for promotion to a post cannot be held as violative of Articles 14 and 16 of the Constitution, the Supreme Court has held. The full bench headed by Chief Justice Bobde set aside a judgment of the Jammu and Kashmir High Court which quashed an administrative order passed by the Chief Justice prescribing certain qualifications for promotion to the post of head assistant. One of the reasons for quashing given by the High Court was that all persons working as senior assistants constituted a homogeneous group and hence there could not have been any difference amongst them on the basis of educational qualification. The Supreme Court, relying on the 1993 judgment passed in T.R. Kothandaraman, held that higher educational qualification is a permissible basis of classification. The Supreme Court has granted bail to Sandeep Gururaj, former Deputy General Manager of Manipal Education and Medical Group, accused of siphoning off funds, reportedly 62 crores, from the company accounts. While granting bail, the court noted that the case is not one that involves public money, but monies of the concerned corporate entities. The Supreme Court has upheld the threshold limit on homebuyers introduced by way of Insolvency and Bankruptcy Code Amendment Act 2020 as an attempt to shield the corporate debtor from avoidable and frivolous applications. The bench, comprising Justices R.F. Nariman, Naveen Sinha and K.M. Joseph, upheld Section 3 of the IBC Amendment Act, which introduced provisos to Section 7 of the Insolvency and Bankruptcy Code 2016 to mandate that there should be at least 100 real estate allottees or 10% of the total number of allottees, whichever is lesser, to maintain an insolvency petition in respect of a real estate project. The court also observed that malice is not a ground to challenge a law made by the legislature. The petitioners had contended that the amendment was created by way of pandering to the real estate lobby and succumbing to their pressure, or by way of placating their vested interests. The Supreme Court has set aside a judgment of the Madras High Court, which had held that obtaining environmental clearances for expansion of National Highway 45A was necessary. The Apex Court held that there is no requirement for obtaining environmental clearance as land acquisition is not more than 40 meters on existing alignments and 60 meters on realignments or bypasses. The court also directed the Ministry of Environment, Forest and Climate Change to constitute an expert committee to examine whether segmentation is permissible for national highway projects beyond a distance of 100 km and, if permissible, under what circumstances. The Supreme Court has held that Section 12 Clause 5 of Arbitration and Conciliation Act, read with the 7th Schedule, which deals with ineligibility of appointment as arbitrator, is a mandatory and non-derogable provision of the Act. Section 12 Clause 5 provides that any person whose relationship with the parties or counsel falls within any of the categories specified in the 7th Schedule shall be ineligible to be appointed as an arbitrator. The benefit of probation under Probation of Offenders Act 1958 is not excluded by the provisions of the mandatory minimum sentence prescribed for offences under the Indian Penal Code, the Supreme Court has observed. In this case, the accused were convicted under Section 397 IPC and were sentenced to undergo rigorous imprisonment of 7 years each. The state contended that since IPC prescribed a minimum sentence of 7 years, it could not be reduced below that period. However, the court, relying on the 1973 judgment in Ishar Das v. State of Punjab, observed that Section 4 of the Probation of Offenders Act reflected the legislative intent that provisions of the Act would have effect, notwithstanding any other law in force. The Supreme Court has observed that before punishing a person for non-compliance of the decision of the court must not only be satisfied about the disobedience of any judgment, decree, direction, writ, or other process, but should also be satisfied that such disobedience was willful and intentional. A rape victim suffers not only a mental trauma, but also discrimination from the society, the Supreme Court said while disposing of a writ petition filed by a rape victim belonging to a scheduled tribe in Jharkhand. The victim had approached the Apex Court in 2019 seeking rehabilitation, submitting that since her identity as a rape victim had been disclosed by the media, she, along with her 3 children, was being refused rental accommodation or any other kind of help from friends or society. The court also reiterated the observations made in the 2019 Nipun Saxena judgment that no person can print or publish in print, electronic, social media the name of the victim or even in remote manner disclose any facts which can lead to the victim being identified. A bench comprising Justices Indira Banerjee and Sanjeev Khanna has observed that a criminal court exercising jurisdiction to grant bail or anticipatory bail is not expected to act as a recovery agent to realize the dues of the complainant. The complainant in his complaint had alleged that the accused had received Rs 41 lakh from him pursuant to an agreement for purchase of land and later refused to execute the sale deed. The High Court had, while disposing the anticipatory bail application filed by the accused, directed him to deposit Rs 41 lakh in court as a condition. The accused approached the Apex Court, challenging this condition. The Apex Court noted that the disputes are civil in nature and by imposing the condition of deposit of Rs 41 lakh, the High Court had virtually issued directions in the nature of recovery in a civil suit, bordering on professional misconduct. Supreme Court to proceed against a lawyer for speculating about the outcome of a pending appeal. The respondent had asserted that her attorney in India had advised her that the appeal pending before the Supreme Court would not succeed at all. The court remarked that they failed to understand as to how said advocate had been in a position to prejudge the outcome of the proceedings or to speculate about the outcome thereof. The Supreme Court has observed that dismissal of a workman by his or her employee cannot be interfered with merely on the ground that it did not conduct a disciplinary inquiry, if the latter could justify the action before the labour court. Where an employer has failed to make an inquiry before dismissal or discharge of a workman, it is open for him to justify the action before the labour court by leading evidence before it, the court said. The Supreme Court, taking note of the pandemic situation, directed a family court in Uttar Pradesh to conduct the trial through video conferencing. In an earlier decision in Santini v. Vijay Venkatesh, passed on 9 October 2017, the Supreme Court bench headed by Justice Deepak Mishra had observed that if proceedings are directed to be conducted through video conferencing, the spirit of the Family Courts Act 1984 would be in peril and cause of justice would be defeated. Justice D.Y. Chandrachud had given a dissenting opinion in the case and opined that the Family Court, as part of rational exercise of judgment, should determine whether video conferencing should be permitted. Those were the top stories from the week. Don't forget to like and share this video. Thank you for being with us. Have a wonderful day.
Subscribe to our channel and press the bell icon to never miss a video from LiveLaw.